Formation of the board. We know that a company is an artificial person created by law and it does not have any physical existence. As such, it cannot act itself. The persons through whom it acts are known as directors. The directors of a company are collectively known as the board of directors. The board must be properly constituted to transact the business of the company validly. Invalidly constituted board cannot bind the company by its acts. However, under certain circumstances, the acts of the directors who have been invalidly appointed would be valid, if the irregularity in appointment is discovered subsequently. Regarding validity of the Act of Director, Section 98 of the Companies Act, 1994 states the following. The acts of a director shall be valid notwithstanding any defect that may afterwards be discovered in this appointment or qualification. Provided that nothing in this section shall be deemed to give validity to act done by a director after the appointment of such director has been shown to be invalid. Regulation 95 of Schedule I of the Companies Act, 1994, which is compulsory, states as follows. All acts done by any meeting of the directors or of a committee of directors or of a committee of directors or by any person acting as a director shall, notwithstanding that it be afterwards discovered that there was some defect in the appointment of any such directors or persons acting as aforesaid, or that they or any of them were disqualified, be as valid as if every such person had been duly appointed and was qualified to be a director. These provisions of the law do not apply to the case of a director whose term of office has expired but continues to act as a director, who from the beginning knew that his appointment was defective. However, the defect in the information of the board cannot adversely affect the right of the outsiders who have no knowledge of defects. A person ignorant of irregularity in the information of the board can claim protection. Number of directors. Section 91 of the Companies Act, 1994, every public company and every private company which is subsidiary of a public company shall have at least 3 directors. Section 92 of the Companies Act, 1994, every private company other than a private company mentioned in Section 91 shall have at least 2 directors. Section 93 of the Companies Act, 1994, only natural person can be appointed as directors. The remuneration of the directors shall from time to time be determined by the company in general meeting. The qualification of a director shall be the holding of at least 1 share in the company, and it shall be his duty to comply with the provisions of Section 97 of the Companies Act, 1994. Appointment of directors. First directors are usually named in the Articles of Association. Section 91 of the Companies Act, 1994 states the followings. 1. Notwithstanding anything contained in the Articles of a company, the subscribers of the memorandum shall be deemed to be the directors of the company until the first directors are appointed. The directors of the company shall be elected by the members from among their number in general meeting, and any casual vacancy occurring among the directors may be filled in by the other directors, but the person appointed shall be a person qualified to be elected as a director under Clause B, and shall be subject to retirement at the same time as if he had become a director on the day on which whose place he is appointed was last appointed as a director. Notwithstanding anything contained in the articles of a company other than a private company, not less than 1/3 of the whole number of directors shall be the persons whose period of office is liable to determination at any time by retirement. Of directors' rotation. If the Articles of Association do not name the directors but specify qualification shares of directors, subscribers shall be first directors. According to Section 97, 1. Directors must take up qualification shares within 60 days of appointment or within such shorter time as may be fixed by the Articles. Regulation 79 of the Companies Act, 1994 states that at the first ordinary meeting of the shareholders, the whole of the directors shall retire from office, and at ordinary meeting in every subsequent year, 1/3 of the directors for the time being, or if their number is not 3 or a multiple of 3, then the number nearest to 1/3 shall retire from office. Regulation 80 states that the directors to retire in every year shall be those who have been longest in the office since their last election, but as between the persons who became directors on the same day, those to retire shall, unless they otherwise agree among themselves, be determined by lot. A retiring director shall, however, be eligible for re-election. The company at the general meeting, at which a director retires in a manner as aforesaid, may fill the vacated office by electing a person thereto. As per Section 17(2) of Companies Act, 1994, Regulations 79, 80, 81 and 82 are compulsory for public company but not for private company, unless it is not a subsidiary of a public company. Consent of directors. Every director has to sign a consent form, Form 9, and file the same with Registrar of Joint Stock Companies and Firms. Section 93 of the Act states as follows. Every person, proposed to as a candidate for the office of a director shall sign, and file with the company, his consent in writing to act as a director, if appointed. A person shall not act as a director of the company unless he has, within 30 days of his appointment, signed and filed with the registrar his consent in writing to act as such director. Powers and duties of the directors. The business of the company shall be managed by the directors, who may pay all expenses incurred in getting up and registering the company, and may exercise all such powers of the company as are not, by the Companies Act, 1994, or any statutory modification thereof for the time being in force, or by these articles, required to be exercised by the company in general meeting, subject nevertheless to any regulation of these articles, to the provisions of the said Act, and to such regulations being not inconsistent with the aforesaid regulations or provisions, as may be prescribed by the company in general meeting. But no regulation made by the company in general meeting shall invalidate any prior act of the directors which would have been valid if that regulation had not been made. The directors may from time to time appoint one or more of their body to the office of managing director or manager for such term, and at such remuneration, whether by way of salary, or commission, or participation in profits, or partly in one way and partly in another, as they may think fit, and a director so appointed shall not, while holding that office, be subject to retirement by rotation, or taken into account in determining the rotation of retirement of directors, but his appointment shall be subject to determination ipso facto if he ceases from any cause to be a director, or if the company in general meeting resolve that his tenure of the office of managing director or manager be determined. The amount for the time being remaining undischarged of monies borrowed or raised by the directors for the purposes of the company, otherwise than by the issue of share capital, shall not at any time exceed the issued share capital of the company without the sanction of the company in general meeting. The directors shall duly comply with the provisions of the Companies Act, 1994, or any statutory modification thereof for the time being in force, and in particular with the provisions in regard to the registration of the particulars of mortgages and charges affecting the property of the company or created by it, and to keeping a register of the director and to sending to the registrar an annual list of members, and a summary of particulars relating thereto, and notice of any consolidation or increase of share capital, or conversion of shares into stock, and copies of special resolutions and a copy of the register of directors and notifications of any changes therein. The directors shall cause minutes to be made in books provided for the purpose of all appointments of officers made by the directors, of the names of the directors present at each meeting of directors and of any committee of the directors, of all resolutions and proceedings at all meeting of the company, and of the directors, and of committees of directors. And every director present at any meeting of directors or committee of directors shall sign his name in a book to be kept for that purpose. Board meeting. A company is an artificial person. It exists in the eyes of the law and cannot act on its own. It has to act through a board of directors elected by the shareholders. A company incorporated under the Companies Act has a distinct legal existence, quite independent the shareholders. The directors are the representatives of the shareholders and the companies are managed through directors. The board meetings are important because the matters relating to the company and its policy are discussed and decided at the board meetings. The Companies Act, 1994 has given discretion to the directors to frame rules and regulations concerning meetings, where they should meet and how their meetings should be regulated. However, if the directors are unable to exercise the powers vested on them, the company may exercise such powers in general meeting of the shareholders. The procedures of dealing with the issues by the directors in one company may differ within the legal frame with that of other company. The scope of business to be done by the board depends upon the provisions in the articles of the respective company and the Companies Act, 1994. Matters within the power. The articles delegate powers to the board of the directors and not to any individual or to a number of individuals by name. Therefore, the directors must meet together as a board in order to discharge their duties. Directors must act together at a properly convened meeting presided over by a chairman. Illustration. Where 6 directors out of 9 met in a different capacity and for different purpose, such meeting is not a board meeting. Directors can meet under informal circumstances. If all the directors meet casually in a club, it cannot be treated as board meeting at the option of one against the will of the other. Usually, articles of a company contain provisions as described below. A resolution in writing signed by the directors required to form a quorum for the time being in Bangladesh shall be effectual as a resolution passed at a meeting of directors duly convened and held. Section 108, 1F of the Companies Act, 1994 states the followings. The office of director shall be vacated if he absents himself from 3 consecutive meetings of the directors or from all meetings of the directors for continuous period of 3 months, whichever is longer, without leave of absence from the board of directors. Therefore, it is not necessary for a director to attend in every board meeting. He may attend as often as possible. A director who attends the meeting must act honestly, use fair and reasonable diligence in the management of the company. A director cannot be held responsible for any misfeasance committed by other directors for an act at meeting in which he was absent or he had no knowledge of it. In the absence of clear provision in the Act or memorandum or articles or resolution, powers of directors depend on surrounding circumstances. Restrictions on power of directors. According to Section 107 of the Companies Act, 1994, the directors of a public company or of a subsidiary of public company shall not, except with the consent of the company in a general meeting, sell or dispose of the undertaking of the company, and remit any debt due by a director. Circumstances when telephonic conversation and informal discussion become board's discussion. Sometimes decisions are taken by the board on the basis of conversation over telephone or informal discussion among themselves. Such telephonic conversation or discussion is not considered as a meeting within the meaning of the Act. However, telephonic conversation and informal discussion may be treated as a resolution subject to provision in the articles and when all the directors sign a resolution based on such conversation or discussion. Resolution through circular solution. If it is provided in the articles, the director may pass a resolution by circulation, signed by all the directors without convening a board meeting. Such a circular resolution must be recorded in the immediate following board meeting and will be incorporated as a part of the minutes of the said board meeting. The articles may allow directors to act otherwise than in a meeting. If the articles so provide, a resolution in writing signed by all the directors for the time being in Bangladesh shall be as valid as if it had been passed at a meeting duly convened and held. The fact that directors should act as combined wisdom is satisfied where they give consent with full knowledge, though they do not meet at any one place. Such signed resolution is inserted in the director's minute book. The resolutions of the board, even if passed by minority at a meeting, are binding on all the directors and all of them are bound by decisions in the meeting. A circular resolution is usually drafted in loose leaf from and one copy is distributed to each director who signs and returns the same to the secretary or chairman. The date of adoption resolution is usually taken at the date on which last copy of the draft resolution signed by the director is received by the secretary/chairman. Directors usually act at board meeting, unless special powers are delegated to directors or committee of the board. The articles usually contain some provisions relating to the meeting of Board of Directors. Regulation 88 of Schedule 1 of Companies Act provides as follows. The directors may meet together for the disposal of business and adjourn or otherwise regulate their meetings, as they think fit. Questions arising at any meeting shall be decided by majority of votes. In case of an equality of votes, the chairman shall have a second or casting vote. A director may, and the secretary on the requisition of a director shall, at any time, summon a meeting of directors. However, this regulation is not compulsory. The articles usually empower the directors for management of the company. They are the persons who can deal with the matters assigned to them. Their decisions cannot be overruled by general meeting of the members, if the directors act in the interest of the company. A draft circular resolution is given in Appendix. Types of business not to be transacted by circular resolution. Not all kinds of business can be transacted by circular resolution. When a director is interested in a contract within the meaning of Section 131, and the articles provide that a resolution in writing signed by all the directors for the time being in Bangladesh should be as valid and effective as if it has been passed at a meeting. A circular resolution approved by all directors, including the interested director, shall not invalidate due to signature of interested director. All business cannot be transacted by circular resolution, where the Companies Act provides a particular business has to be transacted in a meeting of the board. Such as declaration of solvency shall have to be made at a meeting of directors as per Sector 290, disclosure of interest in respect of contract as per SEC 130. Formal board meeting, frequency and interval as per Companies Act. According to Section 96, the Board of Directors shall hold board meeting at least once in every 3 months and at least 4 meetings in every year. Necessity of notice. The first requirement to hold a valid and formal board meeting is serving of notice of the meeting. The directors are required to receive notice of the meeting to meet together. The notice must be given to convene a meeting, otherwise, the meeting becomes irregular and invalid. If one or more of the directors remain absent, the proceeding would be invalid if the validity of a meeting of directors is questioned due to non-service of the notice to all the directors. The burden to prove is upon him who alleges non-service of notice. Companies Act, 1994 does not prescribe the form of notice and mode of service of notice. The notice is usually served in the company's letterhead, stating the date, times and place of the meeting. According to Section 95, notice of board meeting shall have to be given in writing to every director for the time being in Bangladesh and at his address in Bangladesh. As per Compulsory Regulations 112, 113, 114, 115 and 116 of First Schedule of the Companies Act, 1990 for the followings are applicable with regard to notice of the meeting. Regulation 113. A notice may be given by the company to any member either personally or by sending it by registered post to him to his registered address or, if he has no registered address in Bangladesh, to the address, if any, within Bangladesh supplied by him to the company for giving of notice to him. Regulation 114. If a member has no registered address in Bangladesh and has not supplied to the company an address within Bangladesh for the giving of notice to him, a notice addressed to him and advertised in a newspaper circulating in the neighborhood of the registered office of the company shall be deemed to be duly given to him on the day on which the advertisement appears. Regulation 115. A notice may be given by the company to the joint holders of a share by giving the notice to the joint holder named first in the register in respect of the share. Regulation 116. A notice may be given by the company to the persons entitled to a share in consequence of the death or insolvency of a member by sending if through the post in a prepaid letter addressed to them by name, or by the title of representatives of the deceased, or assignee of the insolvent, or by any like description, at the address, if any, in Bangladesh supplied for the purpose by giving the notice in any manner in which the same might have been given if the death or insolvency had not occurred. Optional Regulation 117 of Schedule I of the Companies Act, 1994 relates to members only, which states that notice of every general meeting shall be given in some manner herein before authorized to every member of the company, including bearers of share warrants, except those members who have no registered address within Bangladesh and have not supplied to the company an address within Bangladesh for the giving of notice to them, and every person entitled to a share in consequence of the death or insolvency of a member, who but for his death or insolvency, would be entitled to receive notice of the meeting. Notice need not to be in a specific form. When all the directors are present, service of notice becomes obsolete. An informal notice calling a board meeting becomes valid provided none of the directors raise any objection about non-service of notice. If any director thinks that proper notice has not been given and he does not complain of the same, the resolution would be valid, specially when he takes part in the proceedings. The notice of company meetings is governed, in general, by following rules. Notice is to be issued with due authority granted by the directors. For all purposes, only directors are authorized to convene a meeting. The company secretary may issue notice for a meeting, but his signature must be qualified by the words "by order of the board." Minimum length of notice required for SL, no. Type of meeting: A. Statutory meeting. Notice period: B. Annual general meeting. 21 days. 21 days. C. Extraordinary general meeting. D. Board meeting. 21 days. No specific time limit. However, this may be specified in the Memorandum of Association of the respective company. Though the Act is silent about the length of notice for board meeting, yet it should reasonably be long, and there should have reasonable interval of time between the date of notice and the date of meeting. Every director has right to have a reasonable notice of meeting. If a director is willing to complain about the shortness of time of the notice, he may do so. However, in absence of any written guideline, best practice is to follow the notice period of 14 days. In case of urgency, board may convene emergency meeting giving a shorter period of notice, provided that no objection is raised by any member of the board. The notice shall be in writing. As per Section 85, 1a, a meeting may be called by a shorter notice if it is agreed in writing. 2. ICAB 2024. In case of an annual general meeting, if all members entitled to attend and vote thereat agree to it, and in case of any other meetings, if the members holding not less than 95% of the paid-up capital of the company and having right to vote at that meeting. If the company has no share capital, if the members holding not less than 95% of the voting right exercisable at that meeting. The period should be in clear days. This means that while determining the notice period, the day of serving the notice and the day of the relevant meeting should be excluded. Apart from the agenda, the notice should clearly state the followings. 2, 3, 4. V. The chronological number of the meeting. Date of the meeting. Day of the meeting. Time of the meeting and place of the meeting. Notice of the meeting of a company along with the statement of the business to be transacted at the meeting shall be served on every member. It is to be served on the followings. Every shareholder who resides in the country. legal representative of the deceased shareholder auditors of the company. Copy of the notice to be given to all directors. Accidental omission to give notice to, or non-receipt of the notice by, any member of the company shall not invalidate the proceedings at any meeting. Section 85, 1b. As per Schedule I of the Companies Act, 1994, the followings are applicable with regard to notice of the meeting. Regulation 113. A notice may be given by the company to any member either personally or by sending it by registered post to him to his registered address, or if he has no registered address in Bangladesh, to the address, if any, within Bangladesh supplied by him to the company for the giving of notice to him. Regulation 114. If a member has no registered address and he has not supplied to the company an address within Bangladesh for the giving of notice to him, a notice addressed to him and advertised in a newspaper circulating in the neighborhood of the registered office of the company shall be deemed to be duly given to him on the day on which the advertisement appears. Regulation 115. A notice may be given by the company to the joint holders of a share by giving the notice to the joint holder name first in the register in respect of the share. Regulation 116. A notice may be given by the company to the persons entitled to a share in consequence of the death or insolvency of a member by sending it through the post in a prepaid letter addressed to them by name or by the title of representatives of the deceased, or assignee of insolvent or by any like description, at the address, if any, in Bangladesh supplied for the purpose by giving the notice in any manner in which the same might have been given if the death or insolvency had not occurred. Regulation 117. Notice of every general meeting shall be given in same manner herein before authorized to every member of the company, including bearers of share warrants, except those members who have no registered address within Bangladesh and have not supplied to the company an address within Bangladesh for giving of notices to them, and every person entitled to a share in consequence of the death or insolvency of member who but for his death or insolvency would be entitled to receive notice of the meeting. Signatory of notice. Regulation 88 of Schedule I of the Companies Act, 1994 provides as follows. A director may, and the secretary on the requisition of a director shall at any time, summon a meeting of directors. Therefore, any director may sign the notice. However, usually notice of the meeting of directors is signed by a director or by secretary with the phrase "by order of the board." Notice of meeting on fixed dates. It is not legally necessary to send notice of meeting on a fixed date. If the articles provide that the meeting would be held at regular intervals or on a fixed day of the month, for example, second Sunday of every month at 10 a.m. at the registered office of the company, and all the directors are aware of such decision. But even in such cases, it is better for the secretary to remind the directors of the meeting by sending a formal notice. Place of meeting. Meeting of the board may be held at any place since the Act is silent regarding the place of meeting which is decided by the board. But the place must not be chosen to prevent attendance of any member of the board. Exception to notice. Notice need not be given under the following circumstances. If a director is out of the country, notice need not be given in the absence of express provisions to the contrary in the articles. If the articles provide for meetings to be held at regular intervals, e.g. monthly or bi-monthly, and the time and place is fixed. Though in such case, notice is often sent to remind the director. If all the directors agree to meet to settle emergency issues and hold the meeting can be held notwithstanding the absence of notice. Effect of not giving notice. If a meeting is convened without giving notice to all directors, the resolution passed at such meeting may be invalid on an action by an aggrieved person. The transactions can, however, be ratified at a subsequent meeting of a validly convened meeting. A director is entitled to have notice of the meeting even if he is outside Bangladesh, if an arrangement has been made with the company for sending such notice to him. The right to receive the notice cannot be waived. Agenda of board meeting. As a matter of practice, the businesses to be transacted in board meeting is stated in the notice. A director is bound to attend a meeting of directors if he had notice when a meeting is going to be held, whether he knows the type of business is to be transacted or not. The board may deal with special business, although notice need not contain such agenda. It is, however, suggested to obtain the consent of the chairman on agenda and to forward it together with the notice. Illustrative agenda of first board meeting. Section 210, 6 Appointment of first auditors. Sector 183, 2A and B Fixation of first and subsequent financial year. Regulation 54, Appointment of the chairman, if not named in the Articles of Association. Regulation 73, Appointment of the managing director, if not named in Articles Association, fix his remuneration. Regulation 77, Approval of design of common seal, opening of bank accounts and its operation, approval of draft of share certificate. Decision on pre-incorporation expenses. Usual agenda for subsequent meeting. Regulation 76, Appointment of officers, legal advisors. Section 38, Approval of share transfer. Section 83, Approval of statutory report. Section 84 and Regulation 49, Calling of EGM. Section 91, See Co-option of Director. Section 101, Appointment of alternate director. Section 103, Sanction of loan. Section 105, Approval of contracts. Section 120, Sanctioning of limit of credit to managing agent. Section 122, Purchase of share of company under same managing agent. Section 155 and Regulation 41, Issue of fresh shares and allotment. Section 181, 3 Determining place of keeping books of accounts other than registered office. Section 184 and Regulation 97, Recommendation of dividend. Regulation 77, Use of common seal. Regulation 24, Forfeiture of shares. Regulation 12, Making of calls. Section 184, Approval of Director's Report and Signing Authority. Section 187, Decision regarding financial year of holding company and subsidiary company. Section 189, Authentication of balance sheet, profit and loss accounts, etc. Section 210, 7 Filling the casual vacancy of the auditors. Section 290, Declaration of solvency. Regulation 31, Conversion of shares into stock subject to previous approval in the general meeting. Creating charges on the assets. Opening of branches. Approval of resignation of director/officer. Approval of capital expenditures. Change of address of registered office, if the full address has not been given in the address clause of memorandum. Attendance and quorum for board meeting. Attendance. Directors attending the meeting must sign the attendance register from which quorum will be ascertained before starting of the business. In practice, some companies take attendance by obtaining signature on the resolution where names of the directors present are recorded. Quorum is the minimum number of members required to enable a meeting to go into session validly, i.e. to conduct and vote on the business to be transacted in the meeting, and must be present to make the proceedings of the meeting valid. Quorum not fixed by articles. If quorum is not prescribed by the articles, the majority of the directors will constitute a quorum. If the articles authorize the board of directors to fix quorum of directors and regulate its business, it also laid down the rule of majority decision. Illustration. Without fixing a quorum at a meeting where all directors except one were present, the board passed a resolution sanctioning the grant of a power of attorney to the general manager on behalf of the company. The defendant contended that as no quorum for the directors' meeting had been fixed, so smaller body than all of the directors should act, and therefore the power of attorney was invalid as the resolution authorizing it was invalid. It was held that ordinarily where no quorum has in fact been fixed, the acts of a major part of the directors for the time being are valid, because there was no such contrary provision in the Articles. Quorum as per Articles and Regulation of Schedule 1. The Articles usually contain provision about the number of directors required to constitute a quorum. Illustration. The Articles of a company provide that minimum number of directors shall be 4 and A, B, C shall be first directors. The first directors shall have the power to appoint the other director. There can be no valid board meeting until A, B, and C appoint the fourth director. Regulation 89 of Schedule 1, it is not compulsory, provides as follows. The quorum necessary for the transaction of business of the directors may be fixed by the directors, unless so fixed shall be 3 if the number of directors is more than 3. Validity of transaction by less than quorum. A board meeting conducted with of a number of directors less than quorum prescribed by the Articles is invalid. The Articles of a company made provision that the business of the company shall be conducted by not less than 6 directors. Therefore, any resolution by less than 5 directors will become invalid. Director leaving the meeting after giving attendance. When number of directors falls below the minimum number fixed for quorum due to departure of any director giving his attendance in the meeting, the business carried thereafter will be invalid if the Articles do not clearly mention that quorum is not required throughout the meeting. Director leaving the meeting in the middle of meeting. The directors cannot transact business in meeting if at any time the number of directors present falls below a quorum, although a quorum was present at the beginning of the meeting. Business at a meeting may be started if quorum is present. There is no express indication in the Act or regulation that quorum is not necessary throughout the meeting. The quorum of the board is required at every stage of the meeting. Unless a quorum is present, the business transacted is void. Illustration. Assuming that 3 directors forming quorum were present at the beginning, one of whom left the meeting after giving attendance and before the proceedings started. The proceedings of this meeting shall be invalid on the ground of quorum not being present throughout unless the Articles expressly provide otherwise to mean that quorum is not necessary throughout the meeting. Conducting board meeting without quorum. Regulation 90 of Schedule 1 of the Companies Act, 1994 states the followings. The continuing directors may act notwithstanding any vacancy in their body, but, if and so long as their number is reduced below the number fixed by or pursuant to the regulations of the company as the necessary quorum of directors, after may act for the purpose of increasing the number of directors to that number or of summoning a general meeting of the company, but for no other purpose. From the above, it is clear that the existing directors can convene a valid meeting of directors only to co-opt directors to increase their number of quorum, if their number has already fallen below quorum. Restriction on interested director to form quorum. A director of a public company or a private company which is a subsidiary of public company cannot vote for resolution in which he is interested. Such director cannot be counted towards a quorum for meeting transacting such business. Assumption of third party regarding proper quorum. Third party will not be affected by the invalidity of a meeting. Objection regarding validity of the proceeding of a company does not affect third parties. Third party may assume that everything was done properly. Chairman of board meeting. There must be a chairman of every meeting appointed strictly in accordance with the provisions of the Articles. According to Regulation 54, not compulsory, of Schedule 1, the Board of Directors shall select one of their members as the chairman who shall preside at every general meeting of the company, provided that the chairman and the managing director shall not be the same person. Regulation 91, the directors shall determine the period for which the chairman shall hold office. According to Regulation 93, if the chairman is not present within 30 minutes, the member may elect chairman for that meeting. However, these two regulations are also not compulsory as per SEC 17(2). The appointment of the chairman in contravention of the Articles is void. Where there is no provision for a casting vote of a chairman in the articles, the chairman cannot give a casting vote. A chairman does not necessarily remain the chairman simply because he is a director. He may be substituted by another director. Where an agenda includes replacement of the chairman whom to be replaced can preside over the meeting. The other directors will vote for appointment of the new chairman in place of the old chairman. Therefore, there is no conflicting situation. Consequences when chairman leaves the meeting without adjournment. If the chairman leaves the meeting without adjournment, the remaining directors, if quorum is present, may appoint a new chairman for that meeting to transact the rest of the business, provided that it must be proved that chairman who left the meeting without adjournment violated his duty and acted dishonestly. Minutes of board meeting. It is very much essential record the actual terms of the resolutions as well as the language of the minutes. Minutes are kept to record the proceedings of the meetings. According to Section 89(1), every company shall cause minutes of all proceedings of general meeting and meetings of its directors to be entered in the books kept for that purpose. Section 89(2) Any such minute, if purporting to be signed by the chairman of the meeting at which the proceedings were held, or by the chairman of the next succeeding meeting, shall be evidence of the proceedings. According to Regulation 76. 1. The directors shall cause minutes to be made in books, provided for the purpose of all appointment of officers made by the directors. I. Of the names of directors present at each meeting of the directors and of any committee of the directors. 2. Of all resolutions and proceedings at all meetings of the company, and of the directors, and of the committee of directors. 2. Every director present at any meeting of directors or committee of directors shall sign his name in a book to be kept for that purpose. Use of the common seal. The common seal of the company shall not be affixed to any instrument except by the authority of a resolution of the board of directors, and in the presence of at least 2 directors and of the secretary or such other person as the directors may appoint for the purpose, and those 2 directors and secretary or other person as aforesaid shall sign every instrument to which the seal of the company is so affixed in their presence. Disqualifications of directors. The office of director shall be vacated if the director I. 2. 3. 4. V. 6. ICAB 2024. Fails to obtain within the time specified in subsection 1 of Section 97 of the Companies Act, 1994, or at any time thereafter ceases to hold the share qualification, if any, necessary for his appointment, or is found to be of unsound mind by a court of competent jurisdiction, or is adjudged insolvent, or fails to pay calls made on him in respect of shares held by him within 6 months from the date of such calls being made, or without the sanction of company in general meeting accepts or holds any office of profit of under the company other than that of a managing director or manager or a legal or technical advisor or a banker, or absents himself from 3 consecutive meetings of the directors or from all meetings of the directors for a continuous period of 3 months, whichever is longer, without leave of absence from the board of directors, or accepts a loan from the company, or 7. Is concerned or participates in the profits of any contract with the company, or 8. Is punished with imprisonment for a term exceeding 6 months. Provided, however, that no directors shall vacate his office by reason of his being member of any company which has entered into contracts with or done any work for the company of which he is director, but a director shall not vote in respect of any such contract or work, and if he does so vote, his vote shall not be counted. Rotation of directors. Regulations 79 to 87 of Schedule I of the Companies Act, 1994 states the followings. Regulation 79. At the first ordinary meeting of the company, the whole of the directors shall retire from office, and at the ordinary meeting in every subsequent year 1/3 of the directors for the time being, or If their number is not 3 or a multiple of 3, then the number nearest to 1/3 shall retire from office. Regulation 80. The directors to retire in every year shall be those who have been longest in office since their last election, but as between persons who became directors on the same day, those to retire shall, unless they otherwise agree among themselves, be determined by lot. Regulation 81. A retiring director shall be eligible for re-election. Regulation 82. The company at the general meeting at which a director retires in manner aforesaid may fill up the vacated office by electing a person thereto. Regulation 83. If at any meeting at which an election of directors ought to take place, the places of the vacating directors are not filled up, the meeting shall stand adjourned till the same day in the next week at the same time and place, and, if at the adjourned meeting the places of the vacating directors are not filled up, the vacating directors or such of them as have not had their places filled up shall be deemed to have been re-elected at the adjourned meeting. Regulation 84. Subject to the provisions of Sections 90 and 91 of the Companies Act, 1994, the company may from time to time in general meeting increase or reduce the number of directors, and may also determine in what rotation the increased or reduced number is to go out of office. Regulation 85. Any casual vacancy occurring on the board of directors may be filled up by the directors, but the persons so chosen shall be subject to retirement at the same time as if he had become a director on the day on which the director in whose place he is appointed was last elected a director. A director so chosen shall be known as an alternative director. Regulation 86. The directors shall have power at any time, and from time to time, to appoint a person as an additional director who shall retire from office at the next following ordinary general meeting but shall be eligible for election by the company at that meeting as an additional director. Regulation 87. The company may by extraordinary resolution remove any director before the expiration of his period of office and may by an ordinary resolution appoint another person in his stead. The person so appointed shall be subject to retirement at the same time as if he had become a director on the day on which the director in whose place he is appointed was last elected a director. Proceedings of Directors. Regulations 88 to 95 of Schedule I of the Companies Act, 1994 states the followings. Regulation 88. The directors may meet together for the dispatch of business, adjourn and otherwise regulate their meetings as they think fit. Questions arising at any meeting shall be decided by a majority of votes. In case of an equality of votes, the chairman shall have a second or casting vote. A director may, and secretary on the requisition of a director shall, at any time, summon a meeting of directors. Regulation 89. The quorum necessary for the transaction of the business of the directors may be fixed by the directors, and unless so fixed shall, when the number of directors exceeds 3, be 3, when the number of directors exceed 3. Regulation 90. The continuing directors may act notwithstanding any vacancy in their body, but, if and so long as their number is reduced below the number fixed by or pursuant to the regulations of the company as the necessary quorum of directors, the continuing directors may act for the purpose of increasing the number of directors to that number, or of summoning a general meeting of the company, but for no other purpose. Regulation 91. The directors may elect a chairman of their meetings and determine the period for which he is to hold office. Regulation 92. The directors may delegate any of their powers to committees consisting of such member or members of their body as they think fit. Any committee so formed shall, in the exercise of powers so delegated, conform to any regulations that may be imposed on them by the directors. Regulation 93. A committee may elect a chairman of their meetings, if no such chairman is elected, or if at any meeting the chairman is not present within 30 minutes after the time appointed for holding the same, the members present may choose one of their number to be chairman of the meeting. Regulation 94. A committee may meet and adjourn as they think proper. Questions arising at any meeting shall be determined by a majority votes of the members present, and in case of an equality of votes, the chairman shall have a second or casting vote. Regulation 95. All acts done by any meeting of the directors or of a committee of directors, or by any person acting as a director, shall, notwithstanding that it be afterwards discovered that there was some defect in the appointment of any such directors or persons acting as aforesaid, or that they or any of them were disqualified, be as valid as if every such person had been duly appointed and was qualified to be a director.